Welcome back to the Deep Dive. We're continuing our journey through the Manual of Patent Examining Procedure, the MPEP.
Yep, and today we're still in Chapter 1400, which is all about correction of patents.
Last time gave us the overview, but today we're getting specific.
That's right. We're zooming in on MPP Section 1405. The title itself tells you the story. Reissue and Patent Term.
Okay, reissue and patent term. Correction seems straightforward, fix a mistake. But patent term, that's the lifespan of the monopoly. Mixing those sounds potentially tricky.
Oh, it is, because reissue under 35 U.S.C. 251, it's a powerful tool. It lets patent owners fix real errors made without any deceptive intent. Maybe claims were too narrow, maybe too broad.
Right, a genuine mistake happened.
Exactly. But then the big question pops up, especially if the error relates to how long the patent should last. Can you use this reissue tool to, well, kind of reset the clock, stretch out the patent's life?
The core tension. Can correction become extension?
And the MPP and the law behind it, they draw a very firm line. The answer is a clear no. So our mission today is to trace exactly how the MPP guides examiners on this, how it walls off reissue from being used just to get more patent term. It's that classic balance, right? Fairness to the patent owner versus the public's need for a predictable end date.
Got it. So let's start at the beginning. What's the fundamental rule about how long a reissued patent can actually last?
Well, the rule is anchored right to the original patent. A reissued patent cannot, under any circumstances, last longer than the unexpired term of the original patent it's correcting.
Unexpired term. Makes sense.
And for most patents you see nowadays, utility and plant patents filed on or after June 8, 1995, that maximum term is generally 20 years.
20 years from when?
From the date the application was filed in the U.S. Or, and this is the critical part we need to unpack, from the filing date of the earliest U.S. application to which it claims domestic benefit.
Ah, okay. So that's the patent term filing date they talk about. It's not always the filing date of this specific application.
Exactly. Those benefit claims, under 35 U.S.C. 120, 121, 365C, they link applications together in a chain.
Right, like saying, this application is a continuation of that earlier one.
Precisely. And if you make that link, that claim, to an earlier domestic application, the 20-year clock starts from the filing date of the earliest one in that chain.
So it pulls the start date backward?
It pulls it backward. It acts as an anchor, like you said earlier. So if your patent finally issues, but it claims benefit back to an application filed, say, 10 years ago,
then you've already used up 10 years of your potential 20-year term.
That's it. You might only have 10 years left from the issue date, or even less, depending on prosecution time.
Okay, I can see why a patent owner might look at that and think, uh-oh, maybe I shouldn't have claimed benefit to that really old case. That was a mistake.
That's exactly the scenario. They see the term implications and wonder if they can use reissue to undo that benefit claim, to sort of sever the chain and reset the start date for the 20-year calculation.
To gain back those years.
Right. But here's that principle of directionality we mentioned. You can sometimes shorten a patent term. Maybe you file a terminal disclaimer to get around a double patenting issue.
Okay, so shortening is possible.
But lengthening. Specifically through reissue by trying to fiddle with those historical benefit claims? Absolutely not. The MPEP is crystal clear.
And just to be super clear, this is about domestic benefit claims, right?
Right.
What about claiming priority to a foreign application?
Good point. No, foreign priority claims under 35 U.S.C. 119, those don't affect this 20-year term calculation. That's based purely on the U.S. filing history.
Okay. So the specific maneuver MPEP 1405 addresses is the patentee filing a reissue application saying, my mistake was claiming benefit under Section 120 to that earlier case. Please delete that reference.
Yes, with the unspoken, or sometimes even spoken, hope that deleting the reference changes the patent term filing date and pushes the expiration date further out.
And the MPP says?
The MPET says unequivocally, deleting or correcting a 35 U.S.C. 120 benefit claim in a reissue does not operate to extend the statutory duration of the patent. Full stop.
Wow. So the rule is absolute. It defines reissue under Section 251 as correcting a defect in the patent, like the spec or claims. Messing with the term calculation isn't considered correcting that kind of defect.
Exactly. Reissue isn't a tool to renegotiate the fundamental length of the monopoly granted by statute. That's fixed based on the historical facts of filing.
It really sounds like the USPTO saw this coming, this potential strategy, and built specific rules to prevent it. But how do they handle it in practice? I mean, the patent owner might not explicitly say, I want more term. They might just file the correction.
Right. They look very closely at the reissue declaration, that's the sworn statement, explaining the errors. What else is being claimed as an error? Is this benefit claim issue the only thing?
Ah, so the context matters.
Immensely. The MPP essentially lays out 3 different scenarios for how the examiner should handle a reissue application that tries to correct continuity data, like a Section 120 benefit claim.
Okay, let's break those down. What's the first scenario, the one where the correction might actually be allowed?
Okay, scenario 1. This is what we can call the permissible correction. Imagine the patent owner files for reissue, and their declaration lists multiple errors.
Multiple problems with the patent.
Yes, and critically, at least one of those other errors is a genuine substantive error that definitely justifies reissue under the statute. Think classic reissue reasons, maybe the claims are too narrow or too broad because of some prior art they found.
So there's a legitimate, recognized reason for the reissue already on the table.
Exactly. Because that valid statutory basis for reissue exists, the office will generally allow the patentee to also correct the continuity data at the same time.
Ah, so it's like, while the engine's out for repair anyway, might as well fix that dent in the fender too.
That's a great analogy. They might submit a corrected ADS application datasheet or maybe amend the specification to just remove the reference to that earlier application. The declaration itself won't be rejected on these grounds because the threshold for reissue, a real statutory error, was met by the other issue.
Okay, that makes sense. And this sounds like but does making that correction actually change the patent term?
And here's the crucial part. No. Even though the document gets corrected, the patent's statutory expiration date remains locked to that original historically accurate earliest filing date. The correction is purely administrative in this context. It grants 0 extra days of patent life.
Got it. So they clean up the record, but the term calculation is unaffected. It's like tidying up, but it doesn't change the underlying legal reality of the term.
Precisely. Now, what about the opposite situation?
Right. What if the only thing they say is wrong is that benefit claim, and it's pretty obvious they just want more time?
That brings us to scenario 2, the rejection. This is the hard stop. If the only error alleged in the reissue application is the presence of that Section 120 benefit claim.
Just that one thing.
Just that one thing. And it's clear, either explicitly or implicitly, that the reason for wanting to delete it is solely to adjust the patent term.
They basically admit it, or it's the only logical reason.
Yes. In that case, the office is very likely to reject the entire reissue declaration.
On what grounds?
For lacking an appropriate statutory error under 35 U.S.C. 251. The logic is, trying to extend patent term isn't a correctable defect in the patent itself. The statute doesn't allow reissue for that purpose, so if that's the only purpose, the application fails the basic requirement for reissue.
Okay, that directly prevents using reissue purely as a term extension tactic. That seems pretty clear-cut. But what if they're a bit more subtle?
Ah, the clever approach.
Yeah, what if they file the reissue, identify the benefit claim as the error, but they don't mention anything about wanting more term? They just submit the correction quietly.
That leads us to scenario 3, the futile correction. So the patentee wants to remove the Section 120 claim. They list it as the error, but they don't explicitly tie it to extending the patent's life. They just submit the paperwork, maybe a corrected ADS or spec amendment.
Okay, so what does the office do then? Do they reject it like in scenario 2?
Usually, no. They typically will not reject the filing solely on the basis that this is the only error, provided it's presented as just correcting the record. They might allow the change to the document itself.
Seems inconsistent with scenario 2. Why allow it if it's the only error? But I suspect there's a catch, a really big one.
There is a massive catch. The office will process the correction, the document might get updated, but during the examination of the reissue application, the examiner will make a note in the official file wrapper.
A note saying what?
A note explicitly stating that this change, this deletion or correction of the benefit claim, has absolutely no legal effect on the patent term.
Wait, so they let you make the change, but then they officially record that the change doesn't do the one thing you probably wanted it to do.
Exactly. It seems counterintuitive, right? Why allow the correction if it's legally meaningless for term purposes?
Yeah, why not just reject it as immaterial, like in scenario 2, if term adjustment is barred?
It goes back to the distinction between correcting the document versus altering the statutory right. Technically, the original benefit claim might have been factually inaccurate or unnecessary on the face of the patent document itself, so the office allows the record to be corrected to reflect that.
Okay, so the paper document gets tidied up.
Right. But the actual calculation of the patent term isn't governed by what's merely written on the patent cover sheet after a correction. It's governed by the statute, 35 U.S.C. 154, which ties the term to the actual historical fact of the earliest application filing date that could have provided benefit under Section 120.
So the law fixes the term based on the real filing history, regardless of whether the patent documents accurately reflected that history initially or after a correction. The examiner's note basically says, document corrected, but the law dictates the term, and that hasn't changed.
You nailed it. That note clarifies for everyone looking at the file history that the underlying statutory duration remains untouched by this specific correction.
So scenario 3 sounds like potentially a lot of effort and expense for the patent owner, only to have the USPTO officially state that it achieved nothing in terms of extending the patent's life.
That's often exactly what it is, a futile exercise in document correction with zero impact on the monopoly's duration. It really hammers home the point. Reissue is for fixing substantive defects in the patent, not for trying to renegotiate the length of the grant.
It maintains that balance we talked about, letting patentees fix real mistakes while protecting the public's interest in knowing for sure when a patent expires.
Precisely. It ensures predictability.
Okay, this principle that correction mechanisms can't be used as backdoor routes to extend statutory rights,
Right.
like patent term. Does this hold true for other ways of correcting patents too, not just reissue?
Oh, absolutely. This isn't unique to reissue. The system generally requires a proper legal hook if you're trying to adjust significant rights post-grant. Think about supplemental examination, or SE.
Right, SE. That's where a patent owner brings new information to the USPTO's attention after the patent has granted maybe information they didn't know about or disclosed during prosecution.
Exactly. Now, let's say a patent owner uses an SE request to tell the office about some factual information that needs correcting. Maybe it's even one of these benefit claim errors we've been discussing.
Okay.
The key question in SE is whether the submitted information raises a substantial new question of patentability, or SNQ.
And what makes a question substantial and new in that context? How does that SNQ threshold work?
Well, an SNQ usually means the information, often prior art, is significant enough that it makes a reasonable examiner doubt whether one or more of the patent claims are actually valid. It has to be something that wasn't previously considered or wasn't fully appreciated during the original examination.
So it has to potentially impact the validity of the claims themselves.
Correct. Now, if the factual correction the patent owner submits via SE, like fixing that benefit claim reference, doesn't involve prior art and doesn't actually challenge the validity of the claims.
If it's just an administrative cleanup, essentially.
Right. If it does not raise an SNQ, then the supplemental examination proceeding will not result in that correction being made through the SE process itself.
Why not?
Because the whole point, the statutory basis of supplemental examination, is to consider, reconsider, or correct information relevant to patentability based on an SNQ. If there's no SNQ raised by the submitted item, the SE mechanism isn't triggered for that item.
So even if the information is factually wrong in the patent, if it doesn't cast doubt on the claim's validity, SE won't fix it.
That's generally how it works for these kinds of administrative or non-SNQ raising issues. The patent owner would likely be directed back to other potential correction tools.
Like reissue, which we just discussed.
Or maybe a certificate of correction, depending on the nature of the error. But crucially, they'd still be bound by the rules of those processes, including the strict prohibition against extending patent term that we just covered in detail for reissue under MPP 1405.
It really is a closed loop, isn't it? The system seems designed to keep the correction of administrative details separate from any mechanism that could alter the fundamental duration of the patent right.
That's a perfect way to put it. It prevents using these corrective tools for purposes they weren't intended for, especially not for extending statutory monopolies.
This has been incredibly helpful. A really clear deep dive into, frankly, what can be a confusing area where patentees might see an opportunity that the rules just don't allow.
Yeah.
So MPP 1405 really locks down that patent term calculation against changes via reissue.
It does. It prioritizes that fixed, predictable term.
Okay, before we wrap up, a couple of important notes for you, the listener. First, a huge thank you to Mike Shepard. He's the creative director who's been instrumental in putting this whole MPEP audio series together.
Yes, thank you, Mike.
And second, a very important disclaimer. Remember, this deep dive is based on our understanding and was generated using AI tools like ChatGPT and Notebook LM. It's for educational and informational purposes only.
That's right. It is definitely not legal advice. Please don't rely on it as such.
For any authoritative guidance, you absolutely need to consult the official MPEP itself, talk to a qualified instructor, or speak with a registered patent practitioner.
Absolutely critical.
Okay, so we've spent all this time talking about how the rules strictly prevent lengthening a patent term through corrections like reissue.
Right. The focus is all on stopping the patent owner from getting extra time.
Which leads to a final thought, kind of flipping the script. We protect the public interest by having fixed terms. Right?
That's the idea. Predictability.
So what happens on the other side? What recourse does the public have if a patent contains an error, maybe a faulty benefit claim that was missed during examination? That makes the patent look like it lasts longer than it legally should based on its actual filing history.
That's a really interesting question.
We have all these rules policing attempts to improperly extend the term, but who polices errors that might improperly overstate the term that was granted in the first place? Something for you to think about.
A fascinating point about enforcement and public interest.
Indeed. Until next time, keep digging deeper.